I'll tell you what it sounds like to me. Sounds like to me he's intending on getting the upper hand. So he goes over there and he can basically, in essence, force her to give whatever answers he wants because the one thing at least he knows or thinks is that if he calls the police, she's in violation. I'm not.
Your Honor, I have
Why?
no good explanation for that.
Tell me what's your client's purpose in sending those to the court.
Allie Zend on behalf of the people, Your Honor.
And good afternoon again, Your Honor. Miles Drew on behalf of Mr. Busick, who's approaching my right. And could you please state your name for the record?
Ryan Michael Busick.
All right, thank you. Go ahead. This is your motion.
Thank you, Your Honor. At this time, people are going to be requesting our original request of a $50,000 surety bond. In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning to people. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw it broken drywall. The door was off the frame. The lock, the deadbolt was still in the lock position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then proceeded to chase her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, you see that it was raining, and they were both covered in rain, I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the two calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation of accusing her of cheating and infidelity on the jail calls. And then the next day, when he's arraigned, after he's arraigned, he calls her again, violating his bond. And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim, and it's very concerning to people given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request, and believe that a personal recognizance bond was an abuse of discretion, Your Honor.
Ms. Franz.
And Your Honor, we would admit that there was a call that occurred on the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean iChat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who's in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have two children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges. And I have expressed not only to Mr. Busick, but to the family, the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness. As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work. And even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he's the provider for these children, and they get their health insurance through his job, and that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail. So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record. And I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for any reason.
Yet you have understood about that, counsel?
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to have made those calls. We would be asking for a $25,000, 10% with the tether.
But he's still, I mean, from the allegations, I mean, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. I mean, after creating, I guess, some damage or allegedly creating some damage to the premises, and things not going well because now you're in custody, you're told by the magistrate not to have contact, and what does he do? He has contact. And about the same thing that the allegations are about.
Right. I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are concerning. We can test them as it relates to the case.
Tell me how I can even be sure that he's going to follow this court's conditions.
Well, I think you have his family sitting right here in the courtroom, that they're accountable, good members of our society that are going to be looking out and holding him accountable. They have, financial interests involved in this case as well. They are living with Ryan. He has no prior record, which I think speaks to the fact that they raised him pretty well up to this trying point here. And I think that the tether, was put in place after these phone calls, and there's been no issues with the exclusion zone. So I think in that respect, the tether is working, Judge. And I think you have members of the community that will be looking out to ensure that your court order is followed by Mr. Busick. And I think this is a real wake-up call for him, quite frankly. This isn't a situation he's used to being into, given his clean criminal record. And I think he's standing up a little bit straighter now after this and understands just how much is on the line after having a stern talking with counsel both last night and prior to court today about the severity of the situation that he's in here, Judge.
In the 14B case, isn't there a no contact?
There is a no contact order in place.
So what's he doing there? I mean, that's the part that's troublesome to me. He has a case in which he's the alleged victim, right, counsel?
Correct.
He knows there's a no contact provision, right?
Yes. Well, the no contact provision would run to the defendant in that case, which is the complaining witness in this case.
How it works. That's not my point. My point is, why is him knowing that? Why is he at her residence?
Well, Your Honor, I would say that I think, these no contact orders, I mean, he shouldn't have been seeing her, but this is a 10-year relationship that goes back to when they were 16 years old. They have children in common. While I certainly would have liked if this was handled.
So that's all fine and dandy. But he knows she's not supposed to have contact, right?
Well, he believed the condition was dropped. But I mean, I would agree that he should not be having contact with
Where
his.
would he get the idea that it was dropped?
I'm not sure, Your Honor.
I don't believe that for a minute. I mean, he knows she's not supposed to. I mean, I'll tell you what it sounds like to me. Sounds like to me he's intending on getting the upper hand. So he goes over there and he can basically, in essence, force her to give whatever answers he wants, because the one thing at least he knows or thinks is that if he calls the police, she's in violation, I'm not.
No, I don't think that that's the situation going on. I mean, when the police officers did bring up the no contact order on the scene, he said that he had thought it had been dropped. I mean, I think he's simply concerned about, these beliefs of infidelity, Your Honor. It's an improper way of going about it without doubt. But given that he has no record, he hasn't had any trying situations. He's only 26 years old. Any trying situations like this in his life, I would view this as kind of a one-off situation, that now that he has the accountability structure in place with his family, being aware of what's going on, being in the courtroom here supporting him, that this type of behavior would not continue. And I expect him to comply with all court orders going forward, Judge.
Anything else from people?
Nothing, I mean, I just have concerns given what the court stated with the no contact order in the 14B case, and given that the victim in her interview with police at the scene states that they're separating. So I don't know why he would go to her residence to accuse her of this break-in and assault her. I don't understand. But nothing else from the people as far as this goes, Your Honor.
All right, and I think you know this, counsel. What I really should do is I should revoke his bond. He doesn't make it a day before he's violating the bond condition.
I understand the court's concern.
It's not. What is troublesome for me is that he violates the bond condition. And when you look at the transcript of what he's talking about in the very first part, it's just a continuation of what got him there in the first place.
And I think this, sorry.
Go ahead.
I was going to say, I think the stern talking to that I've had with both him and his family about the, concerning nature of these allegations, the phone call transcript, I think that he's been very receptive to my feedback, and I don't see that this being an issue going forward. This was, within a day of the incident, his emotions were still very, high in charge. It's obviously no excuse for doing what he did, but given that.
Counsel, that's part of my problem. Part of my problem is it doesn't seem that he can de-escalate, because he gets involved in this thing, gets arrested. This fixation that he has on this infidelity, even after he's arraigned, even after he's warned, admonished what he can do, what he can't do. Within hours of that, he can't step back. He just can't.
I understand the court's concern. I would say, while I would not have advised him to send any of those emails to the court, the fact that he's reaching out to the court, not to her, is some indication of change from the, Friday before.
No, it's really not.
He's not reaching out to her. I certainly would not have advised him to send those emails, and I've instructed him going forward not to do anything like that and to run anything he's doing with these cases through counsel going forward.
Even the emails are concerning. In the emails, he's trying to get her in trouble, trying to use this as leverage against her in the other case. He just can't stop. Even if it's not contacting her, it's this continued obsessive feelings towards this victim.
I'm certainly not pleased with the emails being sent, but I would note that it does appear that there are potentially bond violations on the other case. That's not a concern for this court here. But it's not like he's making up and frivolous.
Why is it even his?
Your Honor, I have
Why-
no good
what-
explanation for that. He's
Tell me what your client's purpose in sending those to the court. What was the purpose in sending those to the court?
wanted to alert them of the bond violations that have been alerted of in his case, Your Honor. It's not anything that he's proud of, but he was going to change his actions going forward.
It's not my court. He knows what court it's in. Why is he sending it here?
I think people commonly get confused about the
No.
14th.
Counsel, look at the very first email. He's not confused because he's real clear about what he thinks is happening with her defaming him.
I meant the
Counsel?
confusion about 14A or 14B, Judge. I
No,
understand.
but I'm saying, why did he send it here? I'm not the judge. He knows it. He's not confused about what court it is at all.
Well, I think he did believe he was reporting it to the court of record, albeit mistakenly, Judge.
Is he going to tell me that if I put him under oath that he thinks he's sending it to the right place?
Yes, he was.
Because I know there is no way. Why is it coming right now?
I sent it.
When were those videos taken? When were those videos taken?
About a month ago. And that was,
She's got a winter sweater on in like May. Really? So if you had them for a month and you think you're contacting that court, what took you so long?
There's no excuse for the timing, Judge.
No, what took him so long? This is his story. He's trying to convince me that he can behave.
would you like me to speak?
Go ahead.
So I didn't want to contact the court because, yes, we were working on things, and I spoke in front of you, and I believe that the no contact was dropped so we could start to work on things. I came in front of you and said that during her case one day.
Your Honor, I would note that it was charged as a felony case, and I know you typically sit on the PCC docket, so you may have been a judge that appeared on that case at some point. My understanding is that currently it is just the misdemeanor domestic violence charge that is still pending against the complaining witness, but I do believe it was a felony case where it's possible you would have been a judge that sat on that docket.
And Your Honor, if the court does remember, you were on that case for PCCs, but the people had declined to address the no contact and change it, given concerns of the case.
If you were looking to report these month-old alleged bond violations, why did the court need to know that now she's defaming you?
I just said there's no excuse for sending it.
There's no excuse for the slander, man.
What?
No excuse for the slander.
Yeah, but how is that a bond violation?
I believe there was an understanding from Mr. Busick that there was some kind of no alcohol or no drug provision as part of her pretrial release order. I believe that's what he understood. Whether that is or is not the case, I'm not sure, Judge.
But then it says, and is now causing defamation against me. Why is that important to the other court?
It's not.
Yeah, it's only important to this court.
Correct.
In this bond hearing.
And I did believe that it was still here. I didn't know it was at 14B.
How come you didn't go through your attorney to send this?
I was not retained at that time, Your Honor.
No, I'm talking, you had a PD at the time. Why didn't you go through her?
I did try to call her that morning after speaking to the prosecutors, I believe. But I was at work and I missed her call back.
When, yesterday?
Yesterday, yes.
So you just decided that you just send it?
Well, yes, so I called the courthouse on my break and I said, where do I contact for breaking bond? I should not have, Your Honor.
Why was it so important for you to report her breaking bond? Let's assume it to be true. Why was that so important right now?
Well, it was
Careful how you answer me.
correct. It was
Because, no, listen. Why was it so important to do that? You had just received an emergency bond motion to change your bond. You then start sending stuff. Why is it so important to now report what you say is a month old? I think they're older than that. The month-old video. Why is it so important to do that this week?
I wasn't thinking, Your Honor.
Why was it so important? I don't care. What was your thinking? Whether clear or not, what was your thinking?
I mean, I really wasn't thinking. I really wasn't thinking clearly. I'm not too sure.
I suspect the court could hear Mr. Busick there. I mean,
I
he has no justification. He clearly wasn't thinking straight. I mean, I think he was feeling the pressure of the bond violations in this case, was aware that, or thought he was aware that she may be violating her bond. There's no good justification. There's no answer that we're going to provide you, Judge, that ultimately
so
satisfies
what makes
you.
me not believe that as he feels the pressure of this case, that he doesn't lash out and do something?
Well, I think his children.
Why would I believe that? He had counsel at the time.
I don't think he had the same trust relationship with that counsel that he has now. And I think knowing how much his children's health care is on the line because of this, because his job is on the line.
It's all on the line. It was
absolutely
on the line after he was arrested. It was on the line when he made that call. It was on the line when he starts sending these emails. It's always been on the line. I don't know why he can't recognize that. And that leads me to believe that no matter what I tell him, he can't do it. If he doesn't understand that from the very beginning, what's at stake? And I do believe that he went over to that unit. He went over there to get her in trouble, just like these emails. That's what he's doing.
No, I don't think that the facts when the case is litigated will show that that was his intention at all, Your Honor. I understand the court having concerns, but I think not only, my talking with him, but now this, bond violation hearing in front of his parents, I think he's going to be standing much straighter. I think he understands it. I wish he was a quicker learner.
It shouldn't take his parents to make him stand up and do right.
It doesn't, Your Honor. I think that he'll prove that going forward on bond. And I think bond, to the extent that he needs help, he can get better help and services outside of jail than he could inside.
Frankly, they shouldn't have to be here.
Right, and he agrees.
I mean, even if the prosecutor objected, they shouldn't have to be here.
And Mr. Busick agrees. He's embarrassed and shamed by what he is putting, not only himself, but his family through in this. He's not proud to be here today, Your Honor.
When is this BCC set?
Thursday.
12.
So this Thursday.
Mm-hmm.
Well, I understand what the people's request. I understand what the defendant's request is. I don't think since he's gotten out until he's called to the carpet, this defendant really does conduct himself appropriately. I don't think that has anything to do with his parents or his family or his upbringing or anything along those lines. He just can't do it. And then start sending, he's got an attorney and he's just sending these emails to the court, accusing her of things. He's in her proximity. He doesn't need to be around her at all. He doesn't need to be contacted. He just continued, and that's the part that is striking to me, is the allegations in this case was that he's arguing about some infidelity. He gets arrested. He goes to jail. He gets arraigned. And at no point after that whole process, after they told him, don't contact her, don't talk to her, he's got attorneys, he's all of those things. What does he do? He calls her again to berate on her, and it's very clear from her responses in the transcript. She doesn't want to talk to him about that. And he just keeps on. And then, if that isn't enough, he then says, oh, okay, well, this is my paraphrase. Well, if you won't answer me, I'm going to try to get you in trouble and get you locked up. So I'm going to send this a month after. He's just playing games. And quite frankly, if he's playing games, he's playing with the wrong judge to play those games. Defendant's bond is going to be set, and the court is going to find on two bases. One, his violation after the bond terms were set, the court can review his bond. But I also think, given the way this defendant is exemplified by everything, that it was indeed an abuse of discretion to set his bond at a personal or cognizant bond in this case. Defendant's bond will be reset. The conditions still apply. His bond will be reset at $50,000 cash surety.
Would you consider a 10% provision, Judge?
Cash surety. You can raise it again if you want to on the 12th, but right now he's going.
Fair enough. I hope you and your staff have a great day.
You do the same, sir.
Thank you, Your Honor.
Thank you.
Sir, that's it for the day.
Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Marie Townhouse, this was attorney by People.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir?
Larry Lee.
All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw, and basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, in her office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I've been concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself, or do you wish the court to sign an order that permits the Office of Manager assigned counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time.
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. That are we talking a 1 month or a 2 week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go on approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the
Okay, but
time to
I
wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. I have reviewed
I'm
that.
going to probably believe that there's more than just
Correct.
2 pages.
Correct, Your Honor.
I just provided copies too, Judge, when he was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. It's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say for the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes.
I think I'm going to be honest with you. I think you're just telling me yes, thinking that you're going to get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
Sure, Judge. I gave it to him on May 8th when he was at my office. He got a
Or the
copy.
2 pages, yes, that's what I have.
No.
The other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage that, again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr.
No. If you're, no.
Do you still? That's why. Would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
August 8th, Your Honor?
Yes, ma'am.
Yes, Your Honor.
All right. Are you going to be able to? So if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we were ready to proceed today. The victim is here on this visitor's waiting since this morning. Victim has also been here previously waiting for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm going to be done. If you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that. But I'm not going to let a delay happen. Okay. We're going to go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right. I'm just.
Double checking. Days works.
Pardon?
Days works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves us. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that. You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You understand that, sir? And you understand that you will not be, the court is not going to treat you worse and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this.
I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, there's that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order of my bond, and, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove,
You're asking me to look at information that would be relevant to the bond hearing?
the text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, this is, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
And I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you.
After reviewing the allegations, the bond violations, the phone calls, the emails, and the defendant's continued focus on the alleged victim, the judge reached a clear conclusion. The court determined that the original release conditions were insufficient and increased the defendant's bond to $50,000 cash. Throughout the hearing, the defense emphasized his clean criminal history, strong family support, stable employment, and willingness to seek treatment. But the court ultimately focused on repeated behavior that suggested an inability to follow court orders. This case serves as a reminder that bond hearings are often less about proving guilt and more about determining whether a defendant can be trusted to comply with conditions while awaiting trial. The judge's ruling sends a strong message. When court orders are ignored, consequences usually follow. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.